This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a statute of limitations will always bar a bad faith action and why facts are important. And even a PPO, health insurance policy's refusal to pay, starts the running of the statute of limitation. In Christina Terry versus Healthcare Service Corporation, a October 27, 2023 decision of the 10th Circuit Court of Appeals, it dealt with the application of Oklahoma Statutes of Limitation. The policy involved was a preferred provider organization or PPO health insurance plan that consists of networks made up of healthcare practitioners, facilities, and affiliates who contract with health insurance companies such as Blue Cross and Blue Shield of Oklahoma, BCBSOK, to provide its insured's medical services known as preferred providers. These practitioners, facilities, and affiliates offer healthcare services to PPO policyholders at reduced rates. Preferred providers accept a previously negotiated price from the insurer as payment for covered services. The insured is not responsible for the difference if a preferred provider bills more than the allowable charge. Consistent therewith, the BCBSOK PPO policy informs the insured that, quote, to take full advantage of the negotiated pricing arrangements in effect between BCBSOK and our network of providers, it is imperative that you use network providers in Oklahoma, close quote. The policy also informs the insured that where the policy's allowable charge for non-contracting provider is less than such provider's billed charges, the insured is responsible for the difference. And according to the policy, quote, this difference may be considerable. Now, due to GT's precarious condition, his doctor recommended GT be transported via air ambulance to the University of Oklahoma's Children's Hospital in Oklahoma City. Rocky Mountain Holdings transported GT and billed charges of $49,999 for the 109-mile trip. RMH submitted a claim to BCBSOK for 100% of its charges, but RMH was a non-contracting provider. Plaintiff stopped paying the policy premiums after October of 2014. The same month she received the third explanation of benefits, or EOB. On December 14, 2014, following issuance of the third EOB, plaintiff inexplicably bypassed the internal review procedures set forth in both the policy and all three EOBs, and instead filed a request for assistance with the Oklahoma Department of Insurance. Plaintiff filed a putative class action of BCBSOK on April 27, 2018, alleging breach of contract, bad faith, and fraud. She invoked the district court's diversity jurisdiction by way of her putative class action. The district court stayed class discovery but permitted discovery to proceed as to plaintiff's individual claims. BCBSOK moved for summary judgment after discovery, and apart from the merits, BCBS argued the applicable limitations period, 3 years on the breach of contract claim pursuant to the terms of the policy and 2 years to the bad faith and fraud claims pursuant to Oklahoma statutes that barred plaintiff's action. The court granted BCBSOK's motion and entered judgment in its favor. The district court held that the policy's limitation provision barred the plaintiff's breach of contract claim. The court observed that the limitations period plainly and unambiguously states no legal action is available later than 3 years after expiration of the time within which a properly filed claim is required by this contract. The Tenth Circuit noted that a reasonable insured who by definition has performed due diligence could reasonably ascertain from the foregoing language that plaintiff filed her breach of contract claim later than 3 years after the expiration of the time within which her policy required her to file an insurance claim. Plaintiff was aware, or certainly should have been aware, of an injury. That is, BCBSOK would not meet her demands at the time. RH, the emergency air service responsible for transporting her infant, had a garnishment order issued against her in February of 2016. Having established plaintiff's knowledge of an injury, the next inquiry the Court of Appeal found was what point could plaintiff have become aware of facts establishing her causes of action for fraud and bad faith. Because plaintiff's claim rests in large part on the terms of her PPO policy. Once she realized her injury, nothing prohibited her at that point from pursuing her bad faith claim based upon the wording of the policy and BSOK's alleged representations regarding coverage, both of which she says entitle her to relief. Plaintiff argued that BCBSOK was exercising bad faith throughout her ordeal and did not stop until just before she filed suit in April of 2018. The plaintiff knew of facts that would put a reasonable person on notice that wrongful conduct caused the harm. In this context, a plaintiff must use reasonable diligence in seeking to discover facts giving rise to a claim for relief. Because plaintiff's bad faith claim accrued no later than February of 2016, the Oklahoma 2-year statute of limitations bars such claim as does the 3-year limitation period. In my opinion, even health insurance policies are nothing more than contracts, and are contracts subject to state statutes of limitation, regardless of the conduct of the insurer. Even if in bad faith, the insured must file her suit within the times allowed by the state statutes of limitation. Plaintiff waited too long, and it was not enough to claim that the insurer, BCBSOK, treated her badly by applying its contract as written. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. It's also free by video at YouTube and or rumble.com. Please, if you found it useful, tell your friends and colleagues about this blog and the videos, and let them subscribe to the blog and the videos. And if you're interested in more detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications or my locals community. Thank you for your attention.